My name is Robert, and today we're talking about Scottsdale DUI. So Arizona has laws that apply all over the state of Arizona, but many people get stopped and cited for a DUI specifically out of the Scottsdale City Court. This video is going to be about that. So the law doesn't change between cities, between Mesa or Chandler or Phoenix or any of the different cities, but different cities do have different policies. And so this video specifically is going to be about Scottsdale, how the prosecutors work, how the court structure is set up, how the judges rule, what you should do immediately, and how to proceed if you or a loved one has been charged with the DUI. So first things first, of course, if you're watching this video, it's very likely that either you or somebody you love or care about has been charged with DUI, and we want to make sure that you understand that you are not a bad person. All right, this is something that happens all the time. It's extremely common, and in fact, I've got a chart here to show you just how common it is. So my office, we're based out of Scottsdale. A little bit about me real quick. I am a defense lawyer. I've been practicing criminal defense my entire career, coming up on 6 years now. Our office is based out of Scottsdale. We're about 5 minutes north of the Scottsdale City Court. We deal with them all the time, and so we help a lot of people through DUIs, and over the years we keep track on a lot of data, and so we've been able to compile it and basically run some numbers on the different crimes that Scottsdale prosecutes. And so we put it together in this chart. And so you can see here that essentially this is a breakdown of all the different types of crimes that Scottsdale police will make arrests for. And this number here is the distribution of them. So how many of each crime are the Scottsdale police arresting people for? And this is not something that covers a very, very large range of time. It's actually only from about 3 months. And so you can see here that DUIs are essentially number one, or number two. Number one is the driving on a suspended license. And a lot of the traffic stops are kind of related. So somebody will be stopped for driving on a suspended license, but then also be charged with DUI. So they're really kind of duplicative. But as you can see, DUIs are very common. The reason they are that common, of course, is because Scottsdale puts a lot of money, a lot of time, a lot of training into really ramping up their patrol. They do saturation patrols. They do very, very heavy enforcements around the holidays. Of course, there's Old Town in the city of Scottsdale. And so they really, really emphasize a tremendous amount of their efforts on these areas, and they really will stop anybody for virtually anything just so they can give them a DUI. So now that we understand that, I did want to reiterate that if you have been charged with one, just remember you're not a bad person. This is something that they really will focus on, and so try to take care of yourself as the case progresses. Make sure you're eating, make sure you're sleeping, go get a massage, go get a nice meal, get some exercise, take care of yourself, because this process can take about 3 to 4 months, and you certainly don't want to be stressed the entire time. You want to make sure you're taking care of yourself. So let's jump into it. So when you get charged with a DUI, you're going to receive a handful of documents. Some documents are going to be different colors and things, but we'll run you through what you've got immediately, or what you should have. So the first document that you'll get will look like this. Okay, it's an Arizona traffic ticketing complaint. You can see here that this gentleman was charged with a number of different DUI violations. He actually had two tickets, so this officer wrote him up pretty significantly, wrote him 2 different violations. But this is the actual document that you'll get that will deal with all of the criminal charges. So this is getting filed with the court, with the city court. The other document that you should get, sometimes you don't, is what's called an admin per se, and it looks like this. All right, so this item here will have this is the officer's name and information. Of course, this individual's name and all his data is blurred out here. But this is going to be the most time-sensitive document that you need to review and you need to pay attention to. This gets filed with the MVD, and this is not related at all to the criminal charges. This is related specifically to your driving privileges. And so if you read the fine print here down in this box, it looks like this here. It will tell you that you've got to take action within 15 days from receiving this document. Otherwise, you lose your right to do anything with that document. And so let's back up a little bit. What is this document saying? It's saying that your license is going to be automatically suspended. Okay, automatically, unless you request a hearing so that you can contest that. So when people hire our office, it's one of the first things that we do. We contact the MVD, we file a notice that we want to have a hearing, and that way we can actually have the hearing, begin to develop the case, investigate, go through discovery, and then decide what we want to do with that. But we'll get more into this here in a little bit, but I want to bring it to your attention if you can only watch 5 minutes of this video. This is the most time-sensitive issue. If you miss the 15 days, you're out of luck. There's nothing else you can do about it. So you want to make sure that you're addressing this immediately. Read which box was checked in your case. On the back, you're going to see instructions on how to request a hearing with the MVD Executive Hearing Office. And then that's something that needs to happen immediately. Like I said, it's very, very important because if you miss it, the MVD can be pretty strict about that. So we're going to get back into that here in a minute. I'm going to diagram it all out, but let's jump back into this document here. So this is the actual traffic ticket or complaint, the document that you get here. And you'll see here that it's got a court date. I actually blurred it out, but the court date tells you have to go over to the Scottsdale City Court. You have to appear for what's called an arraignment. All right, and so we're going to diagram that out here shortly, but you can see that this officer, it's Officer Roberson. We see him a lot. He writes a lot of traffic tickets, a lot of DUIs. He's out there, part of the DUI patrols. And so he wrote this individual with multiple DUIs, and he stacked them on top of one another. So you can see you've got the regular kind of DUI, the impaired to the slightest degree. Then you have the legal limit DUI, the .08. Then you have the extreme DUI, and then you have the extreme DUI with the .20 or above. So in a lot of fields, we call this super extreme DUI. And so we'll run through exactly what that looks like. Let me grab my whiteboard here so we can take a look at it. So let's just give you a quick overview on how DUIs work in Arizona, because this can be confusing to a lot of people. People will wonder, why was I charged with 4 DUIs when I was just stopped one time? And there's a reason for that. And so as we kind of saw on the document, they write these DUIs and they stack them on top of one another. So you have the impaired to the slightest degree, then you have the .08, then you have the .15, and then you'll have the .20. All right, now above these DUIs are aggravated DUIs. These are all felonies. So these are for, DUI if you have a suspended license, if you're on your 3rd DUI, if you have children in the car, something along those lines. That's when they will make these aggravated DUIs and they'll take them up to the next level. But if you're out of the Scottsdale City Court, they cannot charge you with an aggravated DUI. So this will be where you're living. All right, and so what they do is the higher that your blood alcohol content goes, they start stacking these charges on top of one another. And of course, as your BAC rises, the penalties will also rise. And our goal is to basically knock these numbers down. And it depends on where some of your blood results come back, where your intoxilyzer, where your breath test comes back at. But you can end up anywhere in this range. And the penalties will increase, like I explained earlier, but they basically will separate at these 2 levels. These are 3 different categories. So if you have, like we saw here, the first 2, the impaired to the slightest degree, and the legal limit DUI, the penalties are essentially the same for these 2. The way that it works is when you're charged with impaired to the slightest degree, it's saying that you can be impaired to any degree, any slightest degree, any minor, even minute level of impairment. They can cite you for that. Now, they don't normally do that for just alcohol-related DUIs. We normally see that for prescription drug DUIs. But they can charge you with that, and they stack that on. Then they'll stack on top of that the .08, which is the legal limit. So if they were to just charge you with this impaired to the slightest degree DUI, then they would have to prove that you were impaired, and they would do that by giving you field sobriety test or by doing the HGN test, the pen test, or the walk and turn test, or any one of those tests. The next level that they charge you with, this is the legal limit. So this is what many people talk about. I'm over the limit. I was over the legal limit. That's the .08. So that means that the blood alcohol content, the amount of alcohol in your blood, was at a .08 level or above. And these 2 penalties are the same. So it doesn't matter which one you get. The penalties don't change for these 2. Now they start to increase in terms of severity when you reach this level, which is called the extreme DUI. So this is where your blood alcohol content is anywhere from a .15 all the way up to a .199999999. It's above the legal limit, but it's below the next level up for the super extreme DUI. And so this is where people will see an increase in jail time, an increase in fines, an increase of an interlock device requirement on your vehicle, and all those different things. The next level up above that is called the super extreme DUI. That's when your blood alcohol content is anything over a 0.20 or above. So 0.2, 0.3, 0.4. We've seen them at 0.4 or above that, which is a very high level, obviously. But that is something that the penalties are the maximum. They can't get any worse than that. So if you're at an extremely high level, they don't get any worse unless you're above that. You're at an aggravated DUI, which, as I said, are felonies. So a big strategy of a lot of defense attorneys is to push these numbers down. You want to make arguments about margins of error. You want to make arguments about where the blood was drawn from, whether there are any contaminants in there, whether there's anything in there that would artificially increase this number up. So our job is to push it down. We want to push it down, as low as we can get it to put you under the threshold where the penalties kick into play. And so down here is what's called a reckless driving. And so if you're doing your research or if you're speaking to attorneys, this is where a lot of the DUIs are going in terms of a plea agreement. People want to take it, what you're charged with as DUIs, and knock it down to a reckless driving. This is a type of violation in Arizona that still is a misdemeanor. It's a class 2 misdemeanor. It still has 8 points on it. It still is a record. It's a criminal conviction that would go on your record, but it doesn't have any of the same mandatory penalties that you would see with the other DUI convictions. And so it's something that defense attorneys really like to push DUIs down towards. And so that's how it works. And so the reason why they stack them on top of one another is because they don't want defense attorneys to get away with it. So say, for example, a defense attorney is able to get the blood that was drawn thrown out. There was an illegal search or an illegal seizure, or there was some lab issues, or somebody who tested it is no longer available, or there's some reason why they can no longer test the blood. And so all of these numbers here were a result of the blood test. But if the blood test can't come in, then they have nothing else to go on. And so we've had that in situations where there's been a chain of custody issue, the blood wasn't impounded properly or whatever it is, and then the government will still try to move forward with the DUI case based on this. They'll try to prove the impaired to the slightest degree. So you can see here that they're just trying to knock these off and go down to the next one. Another example would be, say somebody's blood result came back at a 0.157, and so they're just barely over this limit. Well, we can, with our margin of error arguments and with all sorts of different variables that come into play in any DUI case, say we can knock off this extreme DUI charge. Well, the government and the lawmakers and the legislatures and everybody who wrote these laws, they don't want the entire DUI to be thrown out because we beat this one charge. So they'll just decide then to move forward on the next charges. And so that's why they stack them all on top of one another. Now, the penalties are not going to stack on top of each other. So you're not going to get a penalty for this, plus a penalty for this, plus a penalty for the other ones. You're really going to have one penalty for all of them, presuming that you're getting convicted of a DUI, which is why you're watching this video, because you don't want that to happen, and of course, neither do we. So that's how it works in Arizona. It's just a brief overview. Okay, these are all class 1 misdemeanors. These are class 2, reckless driving is a class 2 misdemeanor. And that's the long and short, that's the nuts and bolts of how the statutes in Arizona work. Now, like I said earlier, so we'll return back to what happens in court. And so you saw that we have a court date here. And so the way that Scottsdale runs their cases, and the reason why we're making a video specifically for Scottsdale, is because they name things differently. They have a very methodical way that they like to move their cases along. They don't like them to last a very long time. And so it's important that you know what happens and when, so that you can have familiarity going into it, and so that you have the best chance of success in resolving your case in a way that's not going to impact you. And so we'll talk about how that works also. So the first court date that you see on the actual citation, which I blacked out, but it should be about 30 days from the date of the violation, is what's called an arraignment, okay? And so that's going to be at the very top. So let's say that we've got a date of violation here, and about 30 days out from there, you're going to have what's called an arraignment, okay? An arraignment is a very, very basic, very preliminary court date. If you have a lawyer, you do not have to go to that. So we contact the court on your behalf, let them know that we've been retained, and they delete that court date. Otherwise, if you don't have an attorney, if you're looking to go get a public defender, something along those lines, or you want to go on to the first court date and just see what happens, it's very, very basic. So essentially, you go into court, You're going to be in a room with a bunch of other people charged with other crimes, and the judge is going to call them up one by one. You may have a chance to meet with a prosecutor or a legal assistant from the prosecutor's office. They may have a plea deal for you. Sometimes they do, sometimes they don't. But really what you do is you go up to the judge tells you what you've been charged with, and then asks what you want to do. Do you want to plead guilty? Do you want to plead not guilty? Do you want to set your case right for trial? Do you want to apply for a public defender? Do you want to continue in so you can go get a private attorney? Those are really the questions that are asked at that time. And so say, for example, you were charged with DUI, the judge would tell you a little bit about what we talked about previously, but it is a Class 1 misdemeanor. Okay, it's a Class 1 misdemeanor. The maximum amount of time in jail that you could get, this is not what's common, but this is the maximum penalty, and the judge needs to advise you about this, is 6 months jail. Same with fines and fees, it's $2,500 plus surcharges. You could get up to 5 years probation. And then there's other penalties that they could impose, things like mothers against drunk driving, things like the interlock device, and all those things are kind of a bit more minor. Most people are concerned about the jail and, of course, the conviction and the license suspension and those things. But what we do from a defense perspective is we just contact the court. We enter a plea of not guilty as to all charges. So everything here. As soon as they know that we've been retained and that we're entering a plea of not guilty, there's no reason for us to go to that court date. And so this court date gets deleted. Then in about 30 days or so, they will reschedule us for what's called a pre-trial conference. So we'll say it's about 30 days out. They'll schedule us for what's called a PTC. We call it a pre-trial. And usually it's a pretty quick, pretty basic type of court proceeding where you do not need to be present, presuming that you've got a lawyer. And we go into court and we have generally a pretty brief conversation with the prosecutor so we can discuss some initial issues with the case. Now, after we initially make our contact here and let them know that we're going to be representing you, there's a number of different motions that we file. One's called a motion for discovery, one's called a notice of our defenses. There's different procedural motions that we're filing. But that happens right here. But what we're really doing is we're saying we want everything in your file. Police reports, officers' notes, body cam footage, dash cam footage, any testing results. We want to start scheduling interviews with the police. There's a lot of material that we want that they have access to, that because you have an attorney, because this is a crime, we have a right to review. It's part of your due process and your rights to defend yourself under the Constitution. And so those requests go out immediately. They're made up here, but sometimes it does take some time for them to actually begin to process those and deliver those to our office and to our attorneys here. And so at the pre-trial, it's really kind of basic. We go in, we talk to the prosecutor. They'll normally have a plea offer there. If there's anything that we've requested that they're dragging their feet on, we can bring it to their attention. We can start to tell them a little bit about what we're looking to get out of the case. We can see what they want out of the case. And in almost every scenario, that court date is not where the case is resolved. So the case will actually move forward and there'll be a continuance. And then there will be what's called a CMC in about another 30 days. So 30 days there, 30 days there. Different things will then be happening between the pretrial and the case management conference. So things like interviews, things like reviewing blood results, things like preparing or filing motions to suppress evidence or motions to compel the disclosure of certain things. There's a lot of different issues that our office deals with behind the scenes, and there's a back and forth between the prosecutor's office and our office. And so there's kind of these little flurries of activities that happen around these court date proceedings. But when we come back to court for the CMC, the case management conference, the judge is going to want to hear from us and make both sides fill out a form. And this is something that is very unique to Scottsdale. Actually, the naming structure here is unique to Scottsdale. Most other courts don't call them these things. And they'll make us fill out a form that looks like this. Okay, it's something that it's very simple. It's a 2-page form. All right, it's something that you could fill out on your own, or your public defender would fill out for you. But it is very important because the judge wants to know at that time, are there any outstanding issues? So if you look here, some of the basic questions are, does the defendant reside out of state? Is all the discovery completed? Discovery meaning police reports, officers' notes, really anything that is transferred back and forth. They want to know if it's completed, and if not, why not? then we could address it at that time. We could say, Judge, we paid for it, we requested it, they have not given it to us, and we now ask you to intervene. We want you to come in, step in, and make them give it to us. They're also asking you, have witness interviews been completed? So in a DUI case, witnesses might be people who saw the accident, people who called 911, people who were at the bar with you, some person who was there who saw something. But more importantly, it's about us interviewing the police. And so we do that. In DUI cases, there's probably about 4 to 5 people on average who were involved, from the officer who made the traffic stop, to the officer who drew the blood, to the officer who transported the blood, who impounded the blood, who did the actual scientific testing, or scientific testing they call it. There's a lot of different moving parts, a lot of different people who are involved in it. And under the rules in Arizona, under the rules of criminal procedure, we have an absolute right to interview them and get them on record so that we can continue to investigate our case, see where they screwed up, but also get them on record so that if the case actually does go to trial, we have something that we can impeach them with, is really why we do it. And so the judge wants to know, have those been completed? And if not, why not? There's also a question about experts, all right? Expert witnesses. By the time we reach the CMC, we should have a better idea of whether or not we want to bring in expert witnesses. So expert witnesses meaning somebody who we want to come in and testify on our behalf about some errors that the crime lab made, or some illegalities that happened during a search, or whatever it is, whatever reason we want expert witnesses to be involved. The judge wants to know at this CMC, this is about halfway through the case, whether they've been retained, and if so, what are their names? So they're just asking us to make sure that that has been disclosed to the court. There's also a question about any outstanding issues. The judge wants to know, are there any issues that they can address to move the case along? And also whether there's any pretrial motions. Are there going to be motions to suppress? Are there going to be motions to compel? Sometimes Scottsdale likes to fight us over things like releasing GPS data, or what's called AVL data, automatic vehicle location data. They really like to battle us over those things. And so the judge wants to know, again, are there any issues, so that they can address them. The real final questions are, have the blood alcohol content results been disclosed? So has the blood been tested? Have those results and the accompanying evidence been disclosed to the defense? Scottsdale, about 3, 4, 5 years ago, they were having a lot of issues with their crime lab, and their testing was being done by the Department of Public Safety. A lot of that has since been fixed, but it's still something that they are, the judge wants to make sure that they are testing these things and disclosing it to us, because there were a lot of issues with that. And so what happens is both the defense attorney and the prosecutor, they sign here at the bottom. They both acknowledge that this is all true. Then that gets turned in. The next court date after that is, again, about another 30 days out. And this is what's called a trial readiness conference. It's called a TRC. And really, this is kind of the last court date to resolve any issues before the case either goes to trial, or you can kind of break off it and you can resolve it by a plea deal. And this is the last setting to do some negotiations, to submit a deviation request, to file any of those more substantive motions, things like a motion to suppress, or motions to preclude testimony, or whatever we deem to be most relevant in your case. We can make those determinations prior to going to trial. So if you like to bookend it, you think the arraignment is the beginning of the case, a trial or a resolution by a plea deal is towards the end of the case. And this is the structure that Scottsdale likes to follow. Sometimes, and they're pretty strict about it. They really like to stick to this format, because they run their caseload sort of like a business. They've got literally court reports that you can go on the internet and find that talk about how many cases they closed, how much money was collected, how many warrants they quashed, all sorts of different, basically key performance indicators that they've got to make sure that the court is functioning properly. It's all on the internet. So they like to move these cases through quickly. Now, sometimes that's not in our interest, and so we will, these cases can last 6 months, a year, sometimes longer than that. It just depends on what needs to happen and when, and how involved the defense is going to be. But they like to resolve it in about 4 months. So you can see there's about 30 days in between each one of them. Sometimes you'll have a continuance here, so you'll have a TRC times 2. or you'll have a trial date that will get continued as well several times. It depends on how old the cases ahead of you are, whether or not your case is going to be going to trial. So that is the general skeleton of how Scottsdale proceeds through. If you have an attorney, we really don't need you to go to any of these, okay, up until probably the TRC. You certainly would have to be at a trial if the case goes to trial, and we need you there if we're going to resolve it in a way that's going to be, a reduction down to a reckless driving or some sort of a deal that is going to benefit you. We would want you to be there so that we could actually enter that formally on the record. The judge is going to want to make sure that you understand your rights and that it's something that you want to do. But aside from that, this is how they generally will run their cases. Now, throughout this process, it's not necessarily related to the actual legalities of the case, but we go through a process with you that's called mitigation. Okay, and mitigation means we're not so much talking about blood results. We're not so much talking about GPS data or dash cam footage. We're not litigating a lot of the legal issues when we're going through this process with you, but we are more focused on you, what you're doing with your life. We want to put this whole situation in context and explain to the court that this is your first offense. This is something that could result in you losing your job. This is something where you're a sole provider for your family. We want to put the whole situation in context a little bit so that we can help not only develop our story, but also use that in our negotiations. So then we can go back to the prosecutor, to the judge, and say, look, there are these current legal issues in the case. We found this issue with the blood. We found this issue with the traffic stop. The warrant had some fatal flaws in it, whatever it is. But also, you are the person that we're working with is a very good individual. You've never been in trouble before. You've got, young children. You're barely over the limit, whatever it is that we need to actually go through in terms of mitigation. We can then use that at each of these settings, and then that is kind of more material that we can use in our negotiations. And so the mitigation is something we start at the very beginning, but it will follow us along. And our firm, we've got a very robust way that we go about doing that. And so that would be something that if you decide you wanted to work with us, we would run through with you. Now, as I said earlier, the MVD is something that is also very important. It is a separate part of this whole process. So your driving privileges, which for many people is critical. I mean, you have to drive to get to work, you have to drive to get to school, you've got children, you have to, curry back and forth to different places. But that is a totally separate entity. The MVD is not anywhere in this list. All right, so the MVD is something that happens over here. And so as I mentioned earlier, when you get this admin per se document, here you have those 15 days to request a hearing. So if we're saying this is the date of the violation and you have 15 days to request the hearing, it's very quick. You can see this rest of this process takes a long time, and so the MVD hearing needs to be filed immediately. What that does practically, so let's say you miss it, you're watching this video too late, or you haven't done that yet, your license is going to be suspended, and it's going to depend on whether or not you have a 12-month suspension or a 90-day suspension. Is going to be dependent upon whether or not you agreed to take the test, the blood test, the breath test, the urine test, whatever they asked you to do. If you refused it, that's what changes it from a 90-day suspension up into a 12-month suspension. So if you miss that, you missed it. I mean, really, there are only a few reasons why the MVD would grant you a hearing after that 15 days, and it's not something that they're very lenient about. So you want to make sure that that is addressed quickly. But if you are watching this video in time where you've retained an attorney, this 15 days is something that we file our MVD hearing request right away. And so the pending suspension, when they are going to suspend your license, that is put on hold. It's called being stayed, meaning the suspension is stayed pending the outcome of the hearing. So say you file that MVD request right here, then they'll grant you a hearing sometime probably in about 30 to 45 days or so, and you'll have the hearing right about here, which you can see is kind of in alignment with what we're doing over here in terms of the pretrial conference in the criminal case. And so if you have your MVD hearing here, this is a hearing where your attorney or you would go in, and it's only related to your driving privileges. It really has nothing to do with whether you're going to jail or whether you're going to have a criminal conviction or anything. It's just regarding whether or not the MVD can validly suspend your license for that period of time, whatever it is. And so we go to this court date sometimes we don't. Sometimes we'll do what's called a stipulation. By the time this hearing comes around, we will have gotten a lot of the police reports, we'll have gotten a lot of the information that we need because we've already gone to the pre-trial conference or we've gotten the discovery and we've done more of our investigation, and we've decided, okay, it serves us no strategic advantage to actually go to the MVD hearing and actually do it. So we'll do what's called a stipulation. There are some benefits to that in terms of insurance rates, in terms of being able to pick when your suspension starts and those types of things. And so we'll just agree to have the suspension start. It's called a stipulation, and we don't actually go to that hearing. Sometimes that doesn't happen. Sometimes we are over here, we decide, okay, we think this is a winnable type of a hearing, and we want to actually go and do it. It can serve some advantages. Certainly it can protect your ability to drive for the near future, but it also will sometimes get the officer under oath so that we can take what he says in this hearing under oath, sworn in front of a judge, and potentially use it in our negotiations or use it in our investigation in the criminal case. So there's a lot of strategic reasons to do it or not to do it, but it's of course going to be dependent upon your specific situation. And so, this is something that is very common all over Arizona, but specifically this format is in Scottsdale, and it's not something that we wish on anybody. It's not a fun thing to go through, but it is important to know how it works because it is a little bit different. Scottsdale has essentially 4 different courtrooms that deal with criminal cases, criminal DUI cases, courtrooms 1, 2, 3, and 4. As of the recording of this video, courtroom 1 has Judge Hendricks, courtroom 2 has Judge Okavaj, courtroom 3 has Judge Yena, and courtroom 4 has Judge Blake. All right. Each one of those judges have different policies in terms of how they sentence people and how they give credit for jail, whether they're going to require jail time, whether they're going to require home detention, and those types of things. Now, of course, the one thing that we did not talk about today was penalties for DUIs. Generally, it's not something that I like to do. My perspective, my position on it is that there's no reason to start planning for the worst. Our goal at my office is to always shoot for the best, always shoot for dismissals, reductions, non-DUI resolutions, and set our sights on that goal. Otherwise, you really don't need a lawyer if you're going to be planning on pleading guilty. All right. In other words, if you do not want to go through that process that I just reviewed with you, if it's something that sounds like it's too much, if you're okay with having a DUI conviction, if you're okay with having some jail time, if you're okay with having a suspended license and an interlock device, save your money on an attorney. You can just go right into court on that first arraignment date and you can just plead guilty and call it a day. Wouldn't recommend that. I'd at least look into the case a little bit further in terms of, even if you have a public defender, just take a look at what's going on, what your results are, if there are any kind of basic rudimentary issues that might be dispositive in your case. You want to make sure that you're going through that. But save your money on a lawyer if you plan on pleading guilty. Otherwise, don't spend money on a lawyer who's just going to do the paperwork for you. You don't need them to do that. You want somebody who's going to walk you through the process, but also identify where there are key issues and where your likelihood of success is as you go through the process. So I do hope this video was helpful in giving you a quick overview on how the Scottsdale City Court works and how DUIs are processed through there. If you do need help, as I said, my office is about 5 minutes north of the Scottsdale City Court. We only do criminal defense law. That's it. No family law, no taxes, no bankruptcy, no business law, nothing else. So if you do want to come in for a free case evaluation, sit down with myself or somebody else from my office and we'll talk you through your case specifically and what it looks like as it's broken down. Thank you for watching.